This session is going to be on strategies for faster dispute resolution. And we are going to have three legal luminaries joining us here. Let me introduce them and invite them to the dais. And this is in alphabetic order. Ms. Ankit Khushu is partner at Kachwa & Partners. Her primary focus is on arbitration, infrastructure, power, and construction. And she's represented clients in high-stake arbitrations administered by various international arbitral institutions as well as ad hoc arbitrations. She's been recognized as a next-generation partner in the dispute resolution litigation of the Legal 500. And may I invite Mr. Khushu to come to the dais, please. We also have with us Mr. Abhishek Kumar, partner, Singhania Partners. In his practice nearing 2 decades, he's successfully represented clients before Supreme Court, High Courts, National Company Law Tribunal, government authorities, and other statutory tribunals. And he's also represented multiple infrastructure companies and has been involved with JVs, infrastructure, M&A, recovery of debts, etc. Mr. Kumar, please. Mr. Kumar, finally, your perspective.
Good afternoon, everybody. I think Mr. Pardasani is correct in saying that things are progressing. We are on the right track. Either we talk about the time limit provided in the Act now for appointment of an arbitrator, or establishment of Commercial Courts Act, or the time limits mentioned for disposal of Section 34 petition or the appeals. So things are on the right track. But still, in my experience, there have been a lot of areas which require some improvement and which will certainly help in expediting the arbitral process in this country. The first issue which I would like to address is, in majority of the arbitrations, including the infrastructure ones, because I'm doing it since last more than 17 years now, I have seen that somehow people feel really very excited about the stage of evidence, about cross-examinations, without realizing that cross-examination, first thing, cuts both ways. Secondly, that really delays the proceedings like anything. To address this concern, probably Section 919 was inserted in the Act, that an arbitral tribunal shall not be bound by the Evidence Act. However, still there is a tendency of the parties to resort to cross-examination. Now, in normal parlance, in infrastructure disputes like overheads, termination, idling claims, price adjustment, variation, all these are majorly based on the documents only, or at the most, issues of interpretation of contracts are involved. However, despite that, people go for cross-examination. In majority of the cases, nothing is achieved from the cross-examination. It only wastes the time and delays the arbitral proceedings. In fact, sometimes it goes to an extent where it can cause really very serious damage. I'll just share one instance. I was doing one arbitration in Northeast against one of the government departments, and the witness who had come to appear on behalf of the government department, he was asked as specific questions. Have you read the affidavit? Have you understood the affidavit? Who has prepared the affidavit? Now, in answer to this question, he says that the affidavit has not been prepared by me. It was prepared by the legal department. And I have just read it. Now, the moment he said so, his testimony goes. There was no cross-examination required further. So, these kinds of things, one, delays the proceedings, and two, sometimes it goes completely against you without achieving anything. So, cross-examination should generally be avoided in an infrastructure arbitration, because majority of the things are based on documents only. There is another area which I feel the legislation can also work on. There is a provision inserted in 2015 that a time period of 6 months was provided for completion of pleadings. Now, if you go through that provision is cannot be said to be mandatory because no consequences are provided for non-fulfillment of that condition. So, I feel that amendment can be introduced, thereby making this provision mandatory. That will really help in expediting things. There is one more issue which we face in many arbitrations, that very old people who are 80 plus, 85 plus, they are being appointed as arbitrators for the reasons best known to the parties that I don't want to discuss. But the thing is that really delays things. It's difficult to make them understand the issues. They don't have hunger for work, and it takes a lot of time to write the award. So one should be careful while appointing an arbitrator that a comparatively younger arbitrator who has some hunger, he should be appointed. That will certainly expedite things. They have more energy and they want to work. Besides that, what happens? People don't realize that at the time of appointment, when this declaration under Schedule 6 comes, sometimes we see that the arbitrator is doing 25 arbitrations, 30 arbitrations, 35 arbitrations. Now, a person who has so many arbitrations, he will not be able to dedicate, sufficient time for one particular arbitration. So, while appointing an arbitrator, that should also be kept in mind. That at the beginning only, when you know that some person is so busy, you may avoid him. Besides that, this 2016 amendment also introduced a provision for imposing cost in arbitral proceedings. But in my experience, arbitral tribunals are really reluctant in imposition of cost on any party. Now, that leads to a situation where a party starts taking undue benefit of this leniency, and that delays everything. Either we talk about filing of pleadings or we talk about completion of proceedings. So, when there is a specific provision provided in the statute, that should be implemented strictly, and that will really help. In courts, we have seen courts, they really don't tolerate any dilatory tactics, and they impose cost comfortably. But the same is not the case in the arbitration. So I think that can really improve the quality of arbitration also and really expedite things. But with these, I would like to just say that things are progressing, but certain improvements are required, which legislature can think of.
Okay.
Thank you.
Thank you.
I'd like to add something what Ankit was just stating. When we talk about delay, I feel there should be some kind of legal training required for all the arbitrators. It's so problematic. I'll give you one example. In one of our matters, which we were doing against a contractor on behalf of a government department, the matter was finally argued. The claim was finally argued. After that, an application seeking amendment in the claim was filed, and that application was allowed. The claim amount was increased up to 6 crores, which is not a small amount. But the worst part was, the shocking part was that it was allowed at the stage when the claim was finally argued. Even the cross-examination in that arbitration was over. So, if probably I felt that it's because of lack of some legal training, that a claim which is finally argued, it's over. Nothing is left. And if at that stage, an application for amendment is being allowed, that's really shocking. That's perverse. So these kinds of things should be avoided, which is, plaguing this law, which was basically enacted to expedite the solution. Instead of that, this has become an extension of litigation, causing more time, causing more delays, which was not the purpose. Maybe Mr. Pardasani, if you would like to add something. Yeah.
Good, I think you have covered most of it. Thank you.
Mr. Prasad. My next question, I'm going to begin with Mr. Prasad this time. I'm sorry, Mr. Kumar this time. Mr. Kumar, are there certain kinds of agencies or certain organizations that are more resistant to faster resolution than others? I'm talking about, of course, in the government ecosystem.
I don't think so. In fact, in infrastructure contracts, it's a standard clause. Either we talk about roads, we talk about ports, we talk about railways. Except DDA, probably they have decided to done away with an arbitration clause. But there is no agency or organization, I would say, which is adverse to this idea of arbitration.
So it's supposed to, as you said, it's supposed to happen within a particular time frame. So just take us through an example of, when it started, how long it took, when it got resolved or didn't. And maybe you can take one of the worst examples. You don't have to name names.
I don't want to take names, and it's difficult to cite one example. But I would like to cite one example in respect of the issue which I highlighted earlier, the cross-examination. There is one matter which we are doing, the claims are more than 350 crores. And approximately 28-30 claims are there, and there are sub-claims under those 28 claims. Now, what happens since last more than 1 year, the cross-examination is happening. Things are not proceeding except cross-examination. Now, if it's natural to have such a long time because there are so many claims, so many issues involved. You can't leave any issue. The problem is, if you leave any issue, tomorrow when the award would go to the court, there would be a question that you did not cross-examine the other side on this aspect, and probably you have conceded this. To avoid that, I suggested that parties in the beginning of the arbitral proceedings only try to do away with cross-examination. Now, I think the award can come only after the final arguments in this matter would be over, and that will take another 1.5 years at least. So how many extensions court can grant? And it's pity for the parties also that they have to face this unnecessary delay. So I think that can be thought about by the legislature, where they can probably make a provision in the act that cross-examination to be allowed or not to be allowed should be decided by the arbitral tribunal, and it should be a pure discretion of arbitral tribunal to deal with that issue. Now, what happens if some party files an affidavit and he asserts that I need to cross-examine the witness of other side because they have filed an affidavit? Arbitrators find themselves completely helpless. They can't ask them no. So I think this issue can be dealt with under the Act.
Okay. Mr. Kumar, I'm assuming here we're talking mostly between government or government kind of agencies and private parties. What about between private parties? Do things happen in a faster way?
I would say, as rightly pointed out by Ashish and Mr. Padasani, that post 2015, things have really been well. Arbitrations are, because there is a time frame now. So even on the government side, I would say that after 2015, not much option is left with them to delay things by, raising frivolous submissions or frivolous objections. And that timeline everybody has to follow. Insofar as private parties are concerned, there are private parties who can still create troubles, but majority of the arbitrations which we are doing for private parties, they are really on a good track, and at least in 24 months, majority of the arbitrations are getting over. But not in 18 months. I must say, parties on their own, by their consent, extend the 6 months time which is provided in the statute, and that's being done in a routine manner. But we can say that many arbitrations concluded in 24 months, and then they got stuck at section 34. There is one matter which is pending since the beginning of 2019, and somehow because of this COVID also they have been a bit unfortunate, the clients. But the petition is not disposed of till now, and they are really worried what is going to happen with my money. So I think probably at court stage something is required to be done. Arbitrations are doing well.
Okay. So when you say within 24 months, are most of them getting done? As in most is 60%, 70%, 80%?
I would say 65 to 70%.
Why is it, I think Mr. Kumar mentioned that sometimes the hearings next hearing will be a few months late. Why would that be the case? Why would the next hearing be, one of you said that one hearing is one day and the next hearing could be a few months from now. Why would that be the case if it's not a court process?
It's again the issue which I just mentioned, that some of, in our country, retired people are doing lots of arbitrations. So the thing is that...
So is there a shortage of arbitrators?
It's not a shortage of arbitrators, I would say, but probably reliance of parties on particular kind of arbitrators which they are choosing. So obviously, when the commodity is in shortage, there will be more demand. So one person would be doing so many arbitrations which are beyond the capacity of one individual. So probably that is the reason why longer dates are being given, because the arbitrator is not available. In one day they have 2 arbitrations, 3 arbitrations, and sometimes 4 arbitrations also. I don't know how they are managing at that age, but that is the reason for longer dates.
Okay. Yeah, please.
I just, what I fully agree with what Ashish just said and Mr. Padasani added. I'll give you one small example which, that there was a recent matter. In any infrastructure contract, extension of time is a very standard thing. It happens very often. Now, in this recent matter, the extension of time was given for 6 months. And after expiry of 6 months, the employer wanted to revisit the time period. Now, this shows that, there is some problem in the attitude also of the employers. They should be reasonable to the contractors, and they should also understand that, you can't reverse the clock for everything. Now, these kinds of things lead to unnecessary dispute. This matter should not have gone to the court, but it went and resulted in so much delay in the execution of the work also.
Okay.
So I think the approach is also required to be improved of both the sides, the contractor side also and the government side also. It's very important.
We are grateful to Mr. Prasad, to Mr. Padasani, to Mr. Kumar, and Ms. Kushu. A big hand for the 4 panelists.